Republic Act No. 1065-4. While at the height of the social reform agenda implementation, where the government actively pushed for the equal access to development opportunities in addressing the long-standing problem of poverty, among other related issues including that of the environment. On February 25, 1998, President Fidel V. Ramos signed into law Republic Act No. 8550, entitled An Act Providing for the Development, Management, and Conservation of the Fisheries and Aquatic Resources, integrating all laws pertinent thereto and for other purposes, otherwise known as the Philippine Fisheries Code of 1998, which took effect on March 23, 1998. On February 27, 2015, the Congress enacted RA No. 1065-4, entitled An Act to Prevent, Deter, and Eliminate Illegal, Unreported, and Unregulated Fishing, amending Republic Act No. 8550. RA No. 1065-4 declares as a policy of the state to adopt the precautionary principles and manage fishery and aquatic resources in a manner consistent with the concept of an ecosystem-based approach to fisheries management and integrated coastal area management in specific natural fishery management areas, appropriately supported by research, technical services, and guidance provided by the state. We have the word fire step, which represent the policy declared by the state. F stands for the flexible policy towards the attainment of the food security. I stands to pursue its commitment to international convention and cooperate with all the states and international bodies in relation to fishing industry. R stands to protect the rights of the fisher folks. E stands to limit access to fishing and aquatic resources for the exclusive use and enjoyment of Filipino citizens. S stands to provide support to the fishery sector. E stands to adopt a precautionary principle and management that is consistent to ecosystem-based approach. And lastly, P that stands to grant private sector the privilege to utilize a fishery. The use of Philippine waters. In Section 2, Article 12 of the Constitution provides that the state shall protect the nation's marine wealth in its archipelagic water, territorial sea, and exclusive economic zone and reserve its use and enjoyment exclusively to the Filipino citizen. The Congress may, by law, allow small-scale utilization of natural resources by Filipino citizens as well as cooperative fish farming with priority to subsistence fishermen and fish workers in rivers, lakes, bays, and lagoons. Consistent with the foregoing constitutional provision, Section 5 of the RA No. 8550 provides that the use and exploitation of the fishery and aquatic resources in the Philippine waters shall be reserved exclusively to the Filipinos. Research and survey activities may be allowed under that strict regulation for purely research, scientific, technological, and educational purpose that would also benefit the Filipino citizen. The enactment of the Philippine Fisheries Code was a welcome breakthrough and considered a major milestone, as this law provides for the reconstitution of BFAR as a line bureau under the Department of Agriculture and created the position of Undersecretary for Fisheries, thereby strengthening the services of the organization for the fishing industry. It also enabled the agency to build strong government and private sector partnership, mainly with the fisher-folk sector, through the institutionalization of the Fisheries and Aquatic Resources Management Councils or FARMCs at the national and local level. The Department of Agriculture is the government agency responsible for the promotion of agricultural development by providing the policy framework, public investments, and support services needed for the domestic and export-oriented businesses enterprises. Under the Philippine Fisheries Code of 1998, the BFAR is headed by a national director and assisted by 2 assistant directors who supervise the administrative and technical services of the Bureau respectively. Furthermore, the said law was instrumental in the establishment of regional and provincial offices to carry out efficiently and effectively its provision. Municipal Fisheries. The municipal or city government shall have jurisdiction over municipal waters as defined in the code. The municipal or city government, in consultation with the pharmacy, shall be responsible for the management, conservation, development, protection, utilization, and disposition of all fish and fishery or aquatic resources within their respective municipal waters. The municipal government, in consultation with the pharmacy, enact appropriate ordinances for the purpose and in accordance with the National Fisheries Policy. The ordinances enacted by the municipality and component city shall be reviewed pursuant to Local Government Code RA number 7160 by the Sanggunian of the province which has jurisdiction over the same. The LGUs shall have enforced all fishery laws, rules and regulations, as well as valid fishery ordinances enacted by the municipal or city council. All fishery-related activities in municipal waters as defined in the code shall be utilized by municipal fisherfolk and their cooperatives or organizations who are listed as such in the Registry of Municipal Fisherfolk. The municipal or city government, however, may, through its local chief executive and acting pursuant to an appropriate ordinance, authorize or permit small and medium commercial fishing vessels to operate within the 10.1 to 15 kilometer area from the shoreline in municipal waters as defined herein, provided that all the following are met. First, no commercial fishing in municipal waters with depth less than 7 fathoms as certified by the appropriate agency. Second, fishing activities utilizing methods and gears that are determined to be consistent with national policies set by the Department of Agriculture. Third, prior consultation through public hearing with the municipal or city pharmacy has been conducted. And lastly, that the applicant vessel as well as the ship owner, employer, captain, and crew have been certified by the appropriate agency as not having violated the code, environmental laws, and other related laws. The local government unit shall maintain a registry of municipal fisherfolk who are fishing or may desire to fish in municipal waters for the purpose of determining priorities among them, of limiting entry into the municipal waters, and of monitoring fishing activities and or other related purposes. The pharmacy shall submit to the LGU the list of priorities for its consideration.
Hi, this is Hajj Sarip Nor Hidayah from Group 8.
Hi, now let's talk about commercial fisheries. No person shall operate a commercial fishing vessel, pearl fishing vessel, or fishing vessel for scientific research or educational purposes, or engage in any fishery activity, or seek employment as a fish worker or a pearl diver without first securing a license from the Department of Agriculture, the period of which shall be prescribed by the Department of Agriculture. Now, what is aquaculture? Aquaculture is fishery operations involving all forms of raising and culturing fish and other fishery species in fresh, brackish, and marine water areas. Fisheries, reserves, refuge, and sanctuaries. Fishing areas reserves for exclusive use of government. The Department of Agriculture may designate areas or areas in Philippine waters beyond 15 kilometers from the shoreline as fishery reservation for the exclusive use of the government or any of its political subdivisions, agencies, or instrumentalities for propagation, educational, research, and scientific purposes. Fish, refuge, and sanctuaries. The Department of Agriculture may establish fish, refuge, and sanctuaries to be administered in the manner prescribed by the BFAR and set aside areas for the cultivation of mangroves to strengthen the habitat and spawning grounds of fish. No commercial fishing shall be allowed in these areas. In municipal waters, the LGU, in consultation with the pharmacies, may establish fishery refuge and sanctuaries. Prohibition and penalties. First, unauthorized fishing. Seizure of items used in illegal fishing considered an incident to a lawful arrest. In Sanson versus Pangilinan case, several persons were apprehended and charged for violation of Section 86 of Republic Act No. 8550 or the Philippine Fisheries Code of 1998. The item seized included a fish net allegedly costing 600,000 pesos with 36 units lights and others. Thereafter, two persons claiming to be the owners of the fishnet filed with the court an urgent motion for the custody of the seized items. In granting the motion, the court held that the law did not provide for the seizure of the fishing paraphernalia pending trial. The prosecutor moved for reconsideration but the same was denied. In reversing the lower court, the court held that the existence of a judicial remedy does not necessarily preclude resort to an administrative remedy. The seizure of the fishing paraphernalia has been made as being an incident to a lawful arrest under Section 12, Rule 127 of the Rules of Court. The seized items ordered released by the lower court have not yet been offered in evidence. Hence, the prosecution, not the court, could still be deemed to be in the legal custody and to have the responsibility over such items. Second, engaging in unauthorized fisheries activities. Third, failure to secure fishing permit prior to engaging distant water fishing. Fourth, unreported fishing. Fifth, unregulated fishing. Sixth, poaching in Philippine waters. 7. Fishing through explosives, noxious or poisonous substance or electricity. 8. Conversion of mangrove forests to fish ponds or any other purpose unlawful. Other prohibitions or violations include those enumerated under Republic Act No. 10654. Now let's talk about administrative adjudication. The Education Committee shall promulgate rules and regulation for the conduct of administrative education and the disposition of confiscated catch, gears, equipment, and other paraphernalia. It shall also issue sub pena in administrative cases before it. A power to issue cease and desist orders and to summarily eject with the necessity of judicial order.